Hello, friends. Welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you're enjoying our legal education content, please remember to subscribe. It helps the channel grow. For tonight's live stream, we are picking up the story relating to Hayley Page and wedding dress design. This is the case of JLM Couture versus Hayley Page Goodman. So let's give a little bit of a recap because it's been a little bit since we discussed this case. So Hayley Page is a fashion designer. She's principally known for wedding dresses. She got her exposure through the show Say Yes to the Dress. She has a fairly expansive social media presence on Instagram and other accounts. And she worked for a company called JLM Couture, which, among other things, produces wedding dresses and wedding-related attire. And so she, as part of her employment agreement, or so the argument goes, sold part of her assets to the company or transferred them to the company. So some of her social media assets to the company, at least for a limited time period. And things happened, and she was fired from the company or left the company or whatever. They're no longer in business together. How about that? And JLM filed for a preliminary injunction, a restraining order that would transfer the assets, the social media assets that were controlled by Gutman back to JLM. And this would include so-called personal accounts from Gutman because maybe they're not really personal accounts, right? Maybe they're really business assets. You can transfer anything to a business. You can sell anything, including a personal things. So you create a personal page. If you want to sell it to a company, you can do that. Then it becomes a company asset like any other asset. It's an asset that you can control and dispose of as you wish. So the argument was that she did this, at least for some time period. JLM sued for an injunction saying, we want this stuff back. She has control of our accounts. She has hijacked our accounts. She has the passwords to many of our accounts. We want them back. The judge, in fact, granted the temporary restraining order. But now for today's story, we're moving back in time, and we're going to discuss Hayley Page's arguments about why the restraining order, which was in fact granted, should not be granted, because we're moving back in time. We covered the complaints. We covered JLM's side of the argument. From JLM's position, we thought or at least I thought the argument was pretty good. We saw the contract language. It seemed to be fairly clear on its own terms. JLM did seem to be asking for a little bit more than they were entitled to. The nature of the contract appeared to only extend to wedding dresses and wedding-related attire, which would presumably not extend to all of Hayley Page's accounts. So there might be an ability to differentiate there. So JLM seemed to be asking for a little bit more than they were entitled to, but not a lot more. The principal argument seemed pretty sound. So we saw some weaknesses in the argument. We saw some problems in the contract language from JLM's point of view that would not give them everything they wanted. But overall, I was at least impressed with JLM's argument. So now we're going to go back and we're going to read Hayley Page's argument as to why she should not be forced to transfer accounts to JLM, give them passwords and so forth and so on. So we're going to read her opposition tonight, and we're going to look for the strengths of her argument and the weaknesses of her argument, and we'll try to decide whether or not we think the judge came to the correct legal decision. How fun. So we're going to do that. Great. So this document is from January because the restraining order was actually issued in March. So we're going to read this argument from January about why the temporary restraining order, the injunction, should not be issued. All right, so we're going to read this, and there's a long list of citations. So let's read what it has to say. JLM asked this court for truly extraordinary relief. I wouldn't describe it as truly, but it is technically extraordinary. Injunctions are an extraordinary remedy. I'm not sure about truly, though. The transfer of ownership of Hayley's highly valuable personal Instagram presupposes TikTok and Pinterest account. Presupposes they're personal. Hayley began using Miss Hayley Page on social media in 2004, and she created her Instagram in 2012, which doesn't really speak to the issue of whether they're company assets now. They might have been personal assets at the time, but you might have sold them because that's a thing you can do when you own something. Over the last 8 years, Hayley has built a community of over 1 million followers by sharing her love, her loss, her personality, and her life with her followers. Sounds like a potentially valuable asset. Everyone, including JLM's employees, understand that Hayley's accounts and the community she built belong to Hayley. Well, no, not everyone, because JLM sharply disagrees with that. Until it was temporarily transferred by court order, the Hayley Page account was 100% Hayley. So there was just by way of what's going on there was a temporary restraining order, right, to issue it immediately. And then there was an injunction. The only difference really is on the timing. TROs happen fast because it's to solve an emergency that's right now. So a temporary restraining order happens very, very quick. And they're also reviewed very, very quick because they tend to happen without the length of the necessary due process. So you go into court on a TRO and say, I need this to happen right now. If it looks really, really persuasive, the judge will say yes. But because they're usually handled so fast, it also denies a little bit of due process. So they tend to be reviewed very fast too, by the same court that issued them. So to give you more chance. So the TRO matured, if you like, into a preliminary injunction. So the temporary restraining orders was give all the assets to the company. And now they're saying why we don't want that to mature into an injunction, a preliminary injunction, which is not a permanent injunction. It can change and will change, I'm quite sure. But it's saying why we don't, a preliminary injunction, well, lasts as long as till it lasts, which is not particularly helpful. But if you had to bet, it would last until the end of the case, although that's not necessary. Preliminary injunctions can be modified along the way. They're preliminary. So until it's a final injunction at the end of the case, they can change. So that's what's going on there. So the court issued the temporary restraining order, do this right now, and will eventually issue the injunction for the preliminary injunction in 2 months from now, or 2 months from then. Anyways, no documentary evidence supports JLM's request. I don't know about that. They have a contract. Indeed, the employment agreement between JLM and Hayley doesn't even mention social media. And I don't know about that either. Let alone that grant JLM's ownership of Hayley's accounts. JLM's claim lies on little more than bald and conclusory association that was understood and agreed the Instagram account was not personal. In fact, the opposite is true. JLM knows full well that Hayley owns the accounts. JLM tells customers that Hayley's Instagram is her own personal account. And JLM does not have any control over what gets posted. JLM may be lying. That doesn't necessarily mean it's not their asset. JLM has exhorted the public to follow JLM on her account, telling them that her Instagram will also brighten up your Monday morning. I don't know how that has any legal effect whatsoever. Its ability to brighten up your Monday morning has pretty much zero legal effect, I think. In 2019, JLM made a new employment contract proposal that sought to include social media responsibilities and to make Hayley responsible for Instagram promotions for the first time. Hayley rejected this contract proposal as it sought to impose duties that were beyond those required of a wedding dress designer, which in this day and age is not necessarily a reasonable thing to argue. Just because you're a wedding dress designer does not necessarily imply that you don't have any social media responsibility. Now, any company of any size, of course, is going to have its own dedicated social media people. Of course they will. But the idea that the face, which is Paige herself, wouldn't have also some responsibility in this domain, even if she's also a designer, that's not really necessarily a conclusion that follows. After the unproductive contract negotiations that followed, JLM began to claim it owned the account in a transparent attempt to gain and exert leverage over its star designer. You know what will help a lot in trying to determine who's right? The contract language. Right? This is the reason that contracts pretty much exist. You don't need contracts when everyone is happy with each other. Contracts exist pretty much solely when someone gets upset. As long as everyone's happy, you don't need contracts now, do you? Contracts are for when someone gets mad, and then we go to the contract language and says, what does it teach us? What does it require? What does it not require? So if we can go to the contract language, which so far we will note has not been mentioned, and she says this is the language and this is what it means, we can interpret it. But so far, she's giving conclusory statements. That's not what the contract says. Great. What is the language and what do you think it says? You know? Since the entry of the TRO, Hayley devoted long-term followers have engaged in open revolt. Okay. They also know that Hayley is also personally owned, controlled, and posted to her accounts. What they know may or may not reflect reality. Hayley's authenticity is a calling card. In response, JLM has posted only a handful of times on Hayley's Instagram. That really has nothing to do with anything. And completely disabled all public commenting on the Instagram, which also has very little to do with anything. JLM's control has caused engagement with the account to plummet and entered a digital death spiral, losing followers and impressions and crushing the value Hayley has created over 8 years. Yeah, but value to whom is the critical question. Whose value is it? If it's the company's value, they have the right to drive it into the ground if they want. It's their value. The fundamental question posed by this court is where JLM is established by clear evidence that JLM owes Hayley's accounts. That is not really the question because it's preponderance of the evidence standard, but let's look past that. JLM has failed to move its burden. The record demonstrates in no uncertain term the accounts are Hayley's, the product of her personal devotion and engagements with fans and followers over the course of a decade. JLM's motion should be denied. It was not, in fact, denied, so let's read a little bit more about why. Okay, so now we have some factual background, which we'll read for whatever value it has. After graduating from Cornell, the reason I say that, incidentally, is because of the standards that govern the analysis of this, right? So we're trying to determine whether or not to grant it. So I say we'll read it for the value it has because it may or may not have value in the end analysis. You know what will really have a lot of value? The contract language. The contract language is going to be very, very key. Almost dispositive, one would say. So her professional background and how her social media accounts came to be and all the rest of it is super duper interesting and all. But you know what the most interesting thing is? The contract language. That's why contracts exist. So after graduating from Cornell in 2007, Hayley began working as an apparel designer for Priscilla of Boston, eventually taking over as lead designer in 2011. From 2007 to 2011, Hayley also began working as a freelance styling assistant, where she worked with high-profile individuals like Pharrell Williams, Kesha, and Tina Taylor. Who cares? Legally, no one cares. It would go to speak to JLM's potential interest in it as an asset. So, Hayley also co-founded a revolutionary bridal gown rental company and started a fashion blog. That's all super interesting. Hayley was an early adopter of social media. In 2004, Hayley opened a personal Facebook account under the name of Hayley Page, using the URL Miss Hayley Page, a term of endearment bestowed to her by her mother. Over the years, Hayley opened other social media accounts using Hayley Page or Miss Hayley Page, including Twitter, LinkedIn, Pinterest, Instagram, Snapchat, Spotify, and TikTok. Like millions of others, Hayley opened the accounts for her own personal reasons. Why she opened the accounts is super interesting and all, but what does the contract language say? In 2012, on recommendation of a friend, Hayley opened her Instagram with a handle of Miss Hayley Page as a quote-unquote personal account. Hayley's first posts to her Instagram were highly personal, included inspirational posts, a photo of Hayley's apartment, and a picture of best friends. The fact, you know, there's a classic statement in law: when you don't have the law, argue the facts. When you don't have the facts, argue the law. So the fact that this is fact forward alone suggests the law is not on our side. Let me tell you all the facts that should make you feel some warm feelings to me. And I, over here as a judge, do not and cannot really have any feelings for you one way or another. I'm not supposed to have feelings. I'm supposed to look at the law and the contract. What did you agree to? If you thought it was that valuable, maybe you shouldn't have sold it. Are you going to argue you didn't sell it? I'm really interested in that argument a lot. But if you're going to be, hey, this was really, really valuable to me, maybe you shouldn't have sold it. If you want to argue you didn't, let me know. Hayley's Instagram has maintained this personal character and authenticity, reflected her life, family, adventures, and work. Hayley used her Instagram to share some of her most personal life experiences, including posts about her childhood and family. Hayley's dog, Winnie, is also regularly featured on the Instagram, along with videos of her and her fiancé cooking and vacation photos. Hayley's Instagram content comes directly from the heart. She regularly shares emotional thoughts and feelings. For example, around Thanksgiving of 2019, she wrote, I know there are inevitable times when the comparison fatigue creeps up for any of us. Or it says comparison, but I'm pretty sure, it says comparison. I'm pretty sure that's supposed to be compassion. But anyways, more often than not, this feels like a community for warm engagement and inspiration. I try to focus on hearing the heartbeats behind the comments and direct messages. And I just want to express my acknowledgement purpose in being authentic as possible on the other end. Gratitude allows you to continually fall in love with your life you have and the people in it. Cheers to the people in my life and the ones I don't even know personally but still feel connected to. I hope, however you spend your Thanksgiving, you find a little extra love and joy. Because Hayley's posts are so personal, she also receives highly personal DMs. An exemplary message is this message, which I'm not going to read because I don't care. Legally, I don't care. In 2017, Instagram verified Hayley's Instagram as a public figure account. Well, it's super duper interesting and all what Instagram did, but they're not a court. So, having verified Instagram is a recognition of authenticity and something that Instagram awards to certain accounts of public figures throughout celebrities and brands. Public figure verification is reserved for individuals as opposed to corporations, which means that this must be a personal account, don't you know? Because Instagram only verifies individual accounts. So that must mean legally this is an individual account, right? Right? Because Instagram making that determination is legally dispositive. Relative rare and entails a rigorous process. Hayley's personal undertook the account of getting her Instagram verified. Hayley's Instagram is instantly recognizable as a personal account. Hayley collected a sampling of 300 posts that show that she has not only posted to Instagram since 2012, but she did so in a very personal way. Hayley's personally created nearly all the content of her Instagram, which includes drafting unique captions for nearly all of her 5,859 posts. She put a lot of work into it. Okay? Hayley has made a deep commitment to her accounts. She answers anywhere from 150 to 200 direct messages per day. That's a lot. Approximately 170,000 over the 8 years since starting her Instagram. Hayley's most common DMs relate to how she became a designer, styling tips, recovering from her divorce, finding love again, and her workout routines. Any time you want to get to the legally operative thing, let me know. Hayley's Instagram has grown organically into a wildly successful account based on the personal moments she shares. Hayley's Instagram largest growth came after publicly sharing her wedding in July of 2015. And her most liked posts are personal, the highest likes going to her engagement posts. Hayley's personal posts often receive upwards of 4 or 5 times more likes than any bridal-related photos. Hayley's Instagram also grew substantially from cross-promotion and tagging celebrities and influential people she knows, including Caitlin Bristow, Lauren Lundrick, Chris Pratt, Sabrina Bryan, and Jay Glazer. I know who one of those people is. In early 2017, Hayley's Instagram reached over 1 million followers. Shortly thereafter, a video of her and her fiancé became her most viewed video, with over 400,000 views. Because Hayley shares very personal aspects of her life on her Instagram, there are also some painful moments that Hayley has shared, but ultimately deleted and or archived, including over 100 photos of her first wedding. Yeah, okay. I believe you. You created the social media accounts. You write a lot of content, maybe all the content, or substantially all. You write substantially all the content. A lot of it's personal in nature. A lot of the communications you get back are personal in nature. Okay. Waiting for the legally operative thing anytime now, Hayley started her Pinterest account on November the 3rd of 2011 and her TikTok account in November 2019. Like her Instagram, Hayley started her TikTok and Pinterest accounts for her own personal reasons. As with her Instagram, no one from JLM asked or otherwise instructed her to open them. On her Pinterest, Hayley regularly pinned images that inspired all aspects of her life, including travel, architecture, color, design, food, and of course, bridal design. That last one might be somewhat important in this analysis. That last one is kind of important, or at least is potentially important, right? If she posted stuff related to bridal design and her contract relates to bridal design, guess what happens? I also like how she mentioned it last in order to try to bury its importance. Nice legal drafting, incidentally. She mentions it last to try to bury its importance. She talks about her wedding, she talks about her divorce, she talks about her workout routine, she talks about her dog, and also sometimes she talks about bridal design. Yeah. On her TikTok, Hayley posts lots of fun content, including videos of her dog, fiance, snowboarding, exercise, dancing, and redecorating her apartment. Examples of this are below, and I like how the very first picture in the very first example is a woman wearing something, to my eye, that looks suspiciously like a bridal dress. Just saying. Hayley's employment with JLM on July the 13th, 2011, at 25 years old, when she is well legally an adult, Hayley signed an employment agreement with JLM. JLM employed Hayley as a designer of a line of brides and bridesmaid dresses. On August the 1st of 2011, Hayley began working at JLM as a head designer for the Blush by Jim collection. The 2011 agreement allowed JLM to use Hayley's name. Finally getting to something legally operative, right? The 2011 agreement allowed JLM to use Hayley's name in connection with bridal dresses and accessories that she created. They're allowed to use her name in connection with bridal design? And by her own admission, the account she created for personal reasons that uses her name also has bridal design stuff on it? I wonder if the agreement which allows the company to use her name in connection with bridal design, I wonder if that might read on the account she created for personal reasons that posts image related to bridal design. On August the 1st of 2014, Hayley signed an amendment to the 2014 agreement, which provides additional compensation for increase in sales. Okay. During her employment with JLM, Hayley served as the head designer for more than 10 bridal collections. Hayley regularly assisted with advertising activities typical of a wedding dress designer, including designing the lookbook and ad campaign images for her collections, directing biannual runway shows for her collections, and attending between 10 and 20 trunk shows each year in person. Those aspects of her employment and all are super, super interesting. but not really relevant to the immediate issue, which is the control of her accounts. The fact that she attended lots of trunk shows and designs runway shows and captures images related to her collections are super, super interesting and all, but what does it have to do with the legal control of her social media accounts? Nothing would be the correct answer to this question. Here's JLM's proposed agreement, or proposed amendment. Around February the 12th of 2019, JLM extended Hayley's current agreement for 3 years, which apparently they have a unilateral right to do under the contract. And if it's in the contract, there's that. In July 2019, Murphy sent Hayley a proposed agreement. The proposal sought to impose even more duties and responsibilities and expand JLM's rights even further. Okay. The 2019 proposal also included a list of promotional and marketing responsibilities beyond the scope of 2011 agreement and the 2014 amendment. Additional duties include, but are not limited to, appearances as a personality on television, radio, and as a speaker, social media monetize opportunities such as YouTube advertising, Instagram, and any all promotional opportunities not currently known. So her original agreement, so let's get this straight. Her original agreement didn't have any social media responsibilities in it, but it did transfer the social media accounts or allowed them to use it or whatever language vernacular we're trying to pick today. So her additional responsibilities to post to the account and help with monetization related to the account, does it speak to ownership of the account? Not really. Not really. The 2019 proposal would also require Hayley to participate in creating and promoting marketing content for its products. Does that relate to the ownership of the media accounts? No. It quickly became clear JLM wished to impose new responsibilities on Hayley relating to Instagram and social media that were beyond her responsibilities as a wedding dress designer and her employment with JLM. Okay, I believe you. JLM wanted to expand the scope of your employment. JLM wanted you to do more stuff than you were previously responsible for. This presumably also would include negotiations over, say, for example, the price that would be responsible for these services, to which, of course, you do not have to agree. It's a negotiation for a contract. JLM says, we'd like you to do this more stuff. Presumably also saying, we'll pay you more money. You can say yes or you can say no to the new agreement. What does that have to do with the old agreement? Not much. 0 things, basically. Hayley responded the proposal was unacceptable, and she sought to clarify the parties' positions with respect to the Hayley Page name. Probably should have done that in 2011 and 2014 and all, but okay. On September the 15th of 2019, Murphy responded that as far as your personal investment regarding JLM, it really is only related to Hayley Page wedding gowns and related categories. But rest assured, I do not claim access to your persona beyond what I described above, which is really, really good because the contract, as I remember, because we covered it in a prior stream, and maybe we'll get the exact language, we'll have to pull it up again. But as I recall, the agreement only allows them to use the name with respect to bridal design, wedding dresses, wedding-related stuff. Not all of her. So him saying, I'm only trying to claim wedding gowns and related categories is, to my mind, pretty consistent with the contract language. I'm not trying to claim anything beyond that. That's good, because you literally can't, because it's not in the agreement. You have claims to some stuff, though. I'm definitely not trying to claim your persona beyond that. Good. In May of 2020, JLM escalated their demands, claiming and seeking ownership over the persona and Instagram. This was the first time anyone at JLM ever expressed a claim of ownership over Hayley's persona or her accounts. I'm not so sure about that. Hayley responded firmly, I cannot accept you or JLM making claim to my personal Instagram and general persona. if it were truly personal, if it were general persona. Due to the hostile nature of Hayley's working environment at JLM, the constant threats and legal harassment, which I'm not sure what that is. Legal harassment? I mean, they're in a contract negotiation. And JLM's various baseless legal claims, it became impossible to working as JLM when she resigned. Great. How does that impact the original contract analysis? JLM's claim in this action. Prior to the entry of the temporary restraining order, in which the judge said, yeah, give them access to all the accounts, at least for the moment, Hayley amassed over 1.1 million followers on her Instagram because of her dedication, care, and cultivation of relationships. Hayley chose at times to use her Instagram to promote the dresses she designed. Kind of an important factual detail now, isn't it? Kind of an important factual detail. She used the Instagram account under her name to promote the dresses she designed. The contract gave JLM control of social media accounts using her name related to bridal designs. She's mixing business with pleasure, as one might say. That's a bad plan, because things like this can happen. You want to try to keep those things separate. When you mix them, yeah. Hayley chose at times to use her Instagram to promote the dresses she designed, which she didn't have an obligation to do, remember, under the original agreement. And by choosing to do so, because she has a vested interest in authentically and ethically sharing the work she's so passionate about. Prior to entry of the TLO, JLM has never had access or ability to post to Hayley's accounts without her approval. And JLM never had control over what content was posted or frequency of the posting. Okay. JLM is also constantly referred to Hayley's accounts as her personal accounts. This is confirmed by several JLM employees who provide declarations in connection with this action. I don't really care very much about what random JLM employees have to say and their random understandings. I really don't care. Contemporaneous correspondence also confirms Hayley's ownership. In a May 2019 email, a JLM employee told a customer that Hayley's Instagram is her own personal account. Did it come from someone in leadership who has legal authority to speak for the company? If so, that'd be great to mention. Similar, when Brittany No was asked whether Bride could be featured on the Instagram, Miss No responded, Hayley's super picky about featuring brides on her page and suggested Bride be directed to JLM's website instead. Random PR person is not exactly legally controlling here. Their random understandings are not very interesting legally. The foundational claim to ownership in 3 declarations submitted by JLM are demonstrably false. Contrary to Mr. Whatever statement, there's never been a period that Hayley posted only wedding gowns all the time. I like how the word only isn't in quotes, which suggests that that's not what he said. I'm guessing that what he said is she posts wedding dresses all the time. Not only wedding dresses all the time. This is demonstrated by hundreds of posts submitted with a Hayley declaration. Similarly, Miss No statement that when I started working at JLM, there are no personal photos of Hayley on the Miss Hayley Page Instagram account that I recall is again demonstrably false. Well, her recollection, if she doesn't recall it, okay, and the fact that first of all, what qualifies as a personal photo in this context, and second of all, whatever. JLM's conclusory claims, particularly in Mr. Murphy's declaration that Hayley accounts were created for JLM's benefit and JLM controlled the content, notice here there are no quote marks, are not supported by a single document and are directly contradicted by Hayley, the content accounts, and JLM's own employees. Not really that interesting. Despite JLM's fixation on Hayley's accounts, JLM has a number of corporate brand social media accounts of its own. JLM has other corporate assets. JLM has other social media account assets. How does that relate to whether or not this is an asset or not? JLM has its other accounts. Okay. And therefore what? How does that relate to whether these accounts are corporate assets or not? It doesn't. Yeah, no. These accounts include some other stuff which I literally don't care about. The JLM brand Instagram account are traditional brand Instagram accounts that are dedicated exclusively to bride-related content. None of JLM's brand Instagram accounts have been verified by Instagram because Instagram's determinations are super duper important in our legal analysis somehow. And the content is starkly different from Hayley's Instagram. The JLM brand Instagram accounts comprises mostly formal JLM created content. Say it with me now. And therefore what? And therefore what? The other accounts are more formal in their nature. There are other corporate assets that they control. And therefore, question. Each Instagram account has a brand profile, which Hayley also uses to post pictures of herself. Public perception of Hayley's accounts. Do I even want to read this section? I really don't, but I guess I will for the sake of completeness, because I literally don't care. I literally don't care. I don't care about public perception. You know what I care about a lot? Contract language. That's what I care about. What everyone else in the world thinks is super duper and interesting and all, but you know what I actually care about? What I actually care about is the agreement between the parties and what it does or does not provide for. What did you agree to or not? Here's what 3,000 people off the street think. Yeah, okay. Shortly after the TRO entered, JLM took control, with thousands of comments expressing shock and disgust. A small sample is below. The public is displeased. The public knew that JLM was misleading them and didn't go over well. Upon review and analysis of Hayley's accounts, Dr. Karen Freeberg determined that the Instagram account was Hayley's personal account for over 8 years, was verified by Instagram as clearly associated with Hayley and not JLM by her 1 million followers. Dr. Freeberg over here, I appreciate her opinion and all, but whether or not it's a personal account is a legal conclusion. Yeah. JLM's control is highly damaging the accounts. Okay, well, maybe they are, but if they're JLM's to control, if they're JLM's to control, JLM can control them for better or for worse. JLM is driving the asset into the ground. And I'm over here as the court, like, okay, they're JLM's to control. So amazingly, not every decision a business makes is necessarily going to turn out well for the business. Businesses sometimes make mistakes. Sometimes they make stupid decisions. Maybe this is a stupid decision on JLM's part. Maybe it's a really bad decision. Maybe it will really hurt JLM's reputation. Maybe it's a bad decision. Here's the thing. People have the legal right to make bad decisions. As long as they're legal bad decisions. People have the right to make decisions for good and bad. That's freedom, man. So if it's legal, you have the right to make bad decisions. Maybe JLM made a bad decision. Maybe it will hurt their company. Maybe it will hurt their corporate assets. I'm over here as the judge, like, and what do you want from me? Hayley is a mega influencer. Ooh. And her Instagram is highly valuable. Sounds like a reason JLM might want it. Industry standard tools place her Instagram account at $28,500 per post. I don't know how that's calculated, and nor do I care. I don't care. I really don't care at all. I don't care if her posts are valued at $1 each or $1 million each. Doesn't matter to me. Not legally relevant. With a true reach of 108,500 followers per post, even after drastically reduced agreement. In just a few weeks since the entry of the TRO, Hayley's Instagram has lost almost 20,000 followers, and its value is dropping precipitously. JLM has disabled commenting, which is critical to engagement. JLM's control is putting Hayley's Instagram into a digital death spiral. Under JLM's control, the value of her Instagram may well drop to the level of other corporate accounts, $4,600 per post. Okay. All right. We are very short. We are very, very short on any legal analysis, really, in this complaint or this response. We are very short on legal response, probably because it's not helpful to us. So let's talk about, like, literally everything else other than what's legally operative, right? JLM's entire argument boiled down, right? JLM's entire argument boiled down is these assets, created personally or otherwise, were contractually given to us under these conditions. So here's what a response really should look like if you have the argument to make it, right? Which you don't, which is why you're doing this. Here's what the argument says, or here's what the argument would look like. Okay, here's some language from the contract, but here's some other language from the contract. Here's other language from the contract. Or that language doesn't mean what you think it means. Here's what it means. Here's what it should mean. Here's how to understand that language. Or there's some sort of defect in the contract somewhere. So it's somehow not legally operative or something. These would be what arguments should look like. JLM says, we have a contract. Here is the language from the contract. Here are the conclusions it compels. Now, as I pointed out before, JLM is being overly aggressive on its conclusions. The contract doesn't go as far as JLM wants to, which would be a perfectly valid thing to point out, but it gets them substantively where they want to be, right? So they do go too far, but unfortunately, the length to which they can go is still way too much for Hayley. So they do overextend their argument, but not in a way that makes their argument non-credible. It's one of those things that's like, yeah, I can tell you're pushing the boundaries and you're a little bit past, but you're not so far past that you've lost my interest. It's like, yeah, you've tried to step a little bit over the line, but I put back behind the line. Unfortunately, back behind the line is nowhere near where Hayley Page wants to be. That's really, really unfortunate at all. And if you have problems with that, please let me know why the language doesn't say what they say it says, or there's other language or other agreement or something. Anything would be fine. A little bit short on that legal analysis. What we have instead is Hayley Page posts stuff that's personal. People think it's a personal account. Random employees think it's a personal account. It used to be super valuable. Now it's less valuable. It has very little to do with anything. Okay, let's talk about the legal standards that apply to the issuing of a temporary restraining order or an injunction. Same standard either way. They're evaluated a little bit different, as a matter of fact. It's technically speaking the same legal standard, but they're evaluated a little bit differently because they come at different times. TROs tend to be reviewed with more skepticism than a preliminary injunction. The reason for that is because they come so fast in the process and without as much due process, sometimes without a response from the other side if it's particularly egregious. So there might not necessarily be any due process to the other side because the due process will come after the fact. I mean, there will be due process, it'll just come afterwards. So TROs tend to be reviewed more skeptically as a result than preliminary injunctions. It's the same legal test, but the way they evaluate is a little bit different. The fact that the TRO issues, though, is suggestive that a preliminary injunction will follow. Although not necessary, because, of course, the court could always realize it screwed up the TRO. It happens. It happens. Courts make mistakes, like everyone else. Sometimes courts get hoodwinked, and then they get really, really upset at the other side when that happens, incidentally, because the court doesn't like being made to look like a fool, right? So if you trick the court and make them look like a fool, they're going to make your life miserable. So probably shouldn't try to do that in the first place. Pro tips to the wise. Anyways, let's review the standards for a preliminary injunction. A preliminary injunction is an extraordinary remedy. Right. Which we noted before when they said it was a truly extraordinary remedy. No, it's an extraordinary remedy. The law says that for sure. It's an extraordinary remedy that's never awarded as a matter of right. Correct. Because it's an equitable remedy, not legal. So therefore, it can't be a matter of right because it's technically speaking, in the strictest possible sense, it's not strictly a legal remedy at all. It's technically an equitable remedy, but whatever. Conclusory allegations lacking supporting evidence will not support a preliminary injunction. That's good because that's not what they had. They had language from the contract. Hayley has used her name on social media continuously since 2004. She has full control and authority over Instagram since she created it in 2012, her Pinterest account since 2011, and her TikTok account since 2019. JLM has never had any control over Hayley's accounts. In a practical sense of they never had passwords to it, maybe, but whose asset was it legally? JLM's attempt to acquire control over Hayley's accounts now will alter rather than maintain the status quo. In such circumstances amounting to a mandatory injunction, okay, is this a mandatory injunction or a preliminary or prohibitory? I guess it is mandatory because it's requiring them to do something as opposed to not doing something is the difference. And they are evaluated a little bit differently. The Second Circuit requires the movement to meet a higher standard with a clear showing. Now, we should be careful here. When it says clear showing, that is not as high as preponderance of the evidence. Preponderance of the evidence is the ultimate standard in the civil case. That's as high as it goes. Well, not strictly speaking, but there's technically some standards higher than that in civil cases, but don't worry about it because it very, very rarely comes up. But anyways, for like the vast, overwhelming majority of civil cases, preponderance of evidence is the end of the road, more likely than not. So when it says clear showing, it doesn't mean 50%. Because if we had 50% plus one, then we're there. We're at the end of the game. So clear showing is more than the amount you would need for a standard injunction or for a prohibitory injunction, but not as much as you need for a mandatory injunction. So how much do you need for a prohibitory injunction? I'm going to give you rough numbers because there's no actual definition of these things. They're a little bit floaty, but I'll give you a definition off my head to tell you what we're talking about. How about that? So a standard injunction or a standard TRO, again, they're technically the same legal standard, but it's viewed with a little bit more skepticism depending on the frame. So a standard prohibitory injunction, what level of confidence do you need? Well, let's say 30%. And how much do you need for a clear showing? 35, 40%, something kind of in that ballpark. Adjust your percentages. Actually, 35, 40% is probably a little high. But you get the idea. Something in that ballpark in terms of our level of confidence. JLM cannot establish a likelihood of success. There's not a single word about social media or Hayley's accounts in either of the employment agreements. Yet JLM asserts it somehow entitled to ownership of these accounts. Indeed, JLM has not presented any documentary proof of its ownership rights, except, for example, the contract. JLM attempts to cobble together ownership claims from selective and misleading parsing of general provisions in the agreement, debunked below. But in the course of its conduct over the past 8 years demonstrates that JLM has fully accepted and understood that Hayley owned the accounts. You're going to try to make some sort of course of conduct argument in this thing? That's going to be really, really tough. That's going to be really, really tough in this particular situation. So the idea is that the course of conduct should be understood to understand what the contract really is. First of all, that's tough generally. Second of all, it's particularly tough in this example because the parties are more linked than in your standard contract because of the employer-employee relationship. So in a course of conduct, like I'll give you an example of, or I'll try to give you an example of what that would mean. So you have a provision in the contract which requires one party to deliver to the other party, I don't know, an amount of timber, right? And over the years, they have been providing a particular grade of timber. And then someone says, well, that's not what that means. So you could get into the understanding of the parties, what they had in mind, right, from the contract language or otherwise. You could get into that, but the course of conduct might also be like, well, you were operating under this agreement, and this obviously was acceptable, so so it can be informative in some situations. But because normally in that kind of situation, the two parties are a little bit more disconnected. Because it's an employer-employee relationship, it's a little bit hard to parse that distinction because the nature of the conduct is more intimately linked. So it's difficult in a normal case, and it's a little bit even more difficult here. So they're going to try to make some sort of course of conduct argument. Absent a clear assignment ownership to JLM, Hayley retains ownership of her accounts. So you want to argue that these are not legally operative. That's good. Right? That'd be great. That's a legal argument. Right? The contract language says this, but that's not legally sufficient language. Right? You actually need this kind of language for this to be legally operative. That can totally be a thing, right? So you might have to put things in particular ways for particular reasons. And it might be, well, this language might suggest it or might be alluding to it, but it's not legally sufficient language. That'd be great, right? If it has to be phrased a particular way and it's not legally sufficient, that'd be a great legal argument. All right. So they say absent a clear assignment of ownership, they retain ownership. All right. Why? In Eagle v. Morgan, and I note right away that it's a district case, because look at the citation. E.D., Pennsylvania. It's a district level case. Non-precedential. This is the best authority we have. Not looking great. So in this random district case, the plaintiff, Eagle, an employee of defendant EDCOM, created a LinkedIn account in 2009. At her employer's urging, gave her the LinkedIn account to certain EDCOM employees to help maintain the account, and was well known in her field. Because, among other things, no policy had been adopted to inform the employees that their LinkedIn accounts were property of the employer, the court rejected the claims that Eagle misappropriated the LinkedIn account as her own. Well, that sounds both factually and legally distinct. There was no policy in place. Well, we have specific language here that we could analyze, right? As opposed to that case, which apparently there was no specific language of any variety. So it's not you screwed up the language. It's you didn't have any language at all. Those are not the same thing. And so, yeah, it's legally distinct and we don't know enough about the facts to even analyze it on its own terms. We have a very coarse summary. So, not impressed with this citation. Similarly, in Marymount, and again, let's just skip ahead to the citation, ND, Illinois, which is not in the Second Circuit. So not only is it a district court, it's a district court in the wrong circuit. Not the greatest legal authority I've ever seen in my life. Similarly, in Marymount, plaintiff Marymount, who was well known in the Chicago design community and responsible for developing and conducting social media campaigns for her employer, created a Facebook and Twitter account for her personal use as well as to promote the company. Despite the company's assertion that directed Marymount to open the account for the company and the company's access to the accounts, the court found that Marymount stated a cognizable ownership because she could promote another employer to her Twitter and Facebook followers, and this following has, in the internet age, become a marketable commercial interest. I see factual differences. I see legal differences. I see the fact that we're not even in the same circuit. I don't see a lot of I don't see any controlling legal authority. I don't see any really great persuasive legal authority. This is the best you got. When this is the best you got, you kind of can stop reading. I got this random district case and this other random district case from a completely different circuit with completely different facts. Not really wonderful. Scraping the bottom of the barrel on this one. JLM's breach of contract theories are meritless and do not support the requested relief. JLM alleges the parties' 2011 agreement establishes its entitlement to an injunction. JLM's position is entirely without merit on the substance, and also fails because injunctive relief is rarely available for breach of contract, since remedy for breach is monetary damages. Citing SDNY, a district case. Also, if money damages will be sufficient, you can't get an injunction, period. One of the standards of I won't go quite as far as to say period, but pretty much period. How about that? One of the standards for an injunction of any kind is it has to be irremediable. It has to be irremediable harm. And if money will make you whole, then we made you whole. So it's not irremediable because we can fix it. If money will fix it, then money can fix it, which means it's not irremediable because money can fix it. So yeah, breach of contract, money damages may be sufficient to fix it. Maybe not. So, Also citing a district court, because this is the best authority we have for some reason. There is no breach of Section 2. JLM argues that Hayley is in breach of its obligation that she assists with JLM's advertising campaigns, and the 2011 agreement broadly requires Gutman to assist JLM in the advertising and marketing of the goods. JLM critically ignores the plain meaning of the provision. Well, now you want to start talking about plain language of provisions? Whoa. Okay. So what does the plain language actually say that we want to actually take note of? Please take note that we're not quoting the other plain language because, we don't want to quote that plain language because not so much for our case, right? So this plain language says, in addition to designing the products, the employee shall perform such other duties and services commensurate with her position as designer as may be assigned to her, including but not limited to assisting with advertising. That's pretty generic. Does it necessarily require her to post on Instagram, particularly when the proposed modified language is making that clear? I don't know, nor at this moment do I particularly care, because whether or not Hayley Page is in breach with respect to her duties on her end of the contract really doesn't say a lot for whether the ownership interest of the asset is. Does she have an obligation or not? At the moment, I can't be bothered to care. Thus, such duties only fall within the employment if they're commensurate with her position as a designer, assigned to her by an officer, and are assisting with advertising. That is a perfectly fine, plain reading of the contract. Although, if it was delegated by an officer, it might be sufficient. But it's a plain reading of the contract, so fine. That didn't happen. Hayley's creation control of a 1 million follower personal Instagram account where she shares her life and personality is certainly not commensurate with her position as a designer. Okay, I agree. She didn't have an obligation to share details of her personal life. I agree. She had no obligation to share details of her personal life. I concede. No officer of JLM ever assigned her duties. Okay. Well, if that's true, and it wasn't delegated, then she can't be in breach. Great. She's not in breach. Super. Hayley accounts have never been an advertising program. They're not operated or controlled by JLM. Yeah. JLM next argues Hayley breached her obligation to devote her full-time attention to the business of JLM. This claim is factually absurd, given that almost 9 years of hard work designing dresses sold exclusively by JLM. Beyond that, JLM has once misstated the terms of the agreement. Please take note that we're very, very willing to state these terms with precision. We're all about stating these terms, and the fact that we didn't state the other terms in no way suggests we're hiding the ball. So the agreement says she should devote her full-time attention during business hours on the company's presence to the business affairs of the company. And she may not, without prior consent of the board, engage in any other business enterprise which requires personal time or attention of the employee and which would interfere with her duties. So this stands for the bombshell proposition that during working hours, she has to work for the company. Ooh. Hayley never breached any of these duties. Not only has JLM failed to produce any evidence of the breach, it was fully aware of the efforts and commitment to her accounts, which she may or may not have any obligation to, which was her whole argument, remember? Her whole argument is that she doesn't have an obligation. So her commitment, from her own point of view, is completely irrelevant because she didn't have the obligation in the first place. So the fact that she did it, JLM never objected or claimed those efforts violated any duty of JLM. Okay. If it's their asset. In any event, even if JLM somehow could establish a breach of Section 3, it could never establish this breach somehow entitles JLM to ownership. I agree. This language does not really, would not allow for that remedy. JLM's account that Hayley's are work for hire fails because they do not fall within the plain language of this section. The work for hire provision expressly identifies dress designs and materials directly related to designs as subjects of the clause. And please take note that in a footnote, we're finally quoting exact language here, which we know. We're just going to start mentioning now. So here's this language from the contract. The parties expressly agree that all designs, drawings, notes, patterns, sketches, prototypes, samples, improvements to existing works, and any other works conceived of or developed by employee in connection with her employment involving bridal design, bridal clothing, bridal accessory, and related bridal or wedding items, either alone or with others, from commencement of her employment through the term and any extension are works for hire. And the ownership of any intellectual property shall be the sole property of the company. So anything related to her job as a wedding dress designer, basically, all the copyrights, for example, yeah, such that it is, But yeah, all that's work for hire. Super. Okay. Hayley's accounts are not dress designs. I agree. Hayley's accounts do not fall within the plain language of this provision of the contract. And like the rest of the 2011 agreement, these provisions make no mention of social media accounts. Anytime she wants to mention the language that JLM is relying on, which is none of this language, I'd like to point out, for the principal issue, anytime she'd like to mention the language that JLM is relying on and say why it does or does not speak to what we're talking about, that'd be just great. Then we could analyze the language and we could analyze her argument. We're 22 pages into this thing, and we have yet to get to the central issue. Not a promising sign if you're reading this as a judge. It's not a promising sign. We're 22 pages into this, and we haven't gotten to the principal issue. It's not like we're trying to avoid it or anything, right? They cannot be read to cover personal media accounts. Sure, and why not? That's fine. What's next? There's no breach of designer names. Ooh, finally, maybe we're getting to something material. Okay, great. JLM also cites Section 10B, which it claims prohibits Gutman from any commercial use of designer's name, which includes Miss Hayley Page. But JLM, again, fails to address the entire section. Okay. What is missing here? What is missing here? I don't know if you noticed it immediately, because I sure as heck did. What is missing here? What would be missing here is the exact language of the contract. Where is footnote 3? Footnote 3 should be making an appearance right about now. We had footnote 2, which quoted the exact language of that contract provision. Remember? It just happened. We just saw it, like just now. We had footnote 2. It provided the exact language from the contract. It was great. And she says, oh, you're misquoting this provision. Where's footnote 3? Where's the exact language of the provision? Just saying. JLM again fails to address the entire section, which we're also going to fail to address because we're not going to mention it, which makes clear that no breach has occurred. Well, why don't you just tell us the whole thing then? If it's that clear, this should be really easy for you, right? All you have to do is quote the exact language of the contract in full confidence that JLM has no response. Section 10A contains a list of names that are defined as her name, Hayley Page, Hayley Page Gutman, Hayley Gutman, Hayley Page, or any derivative. Section 10A states further that the assigned names of those are only in connection with the design, manufacture, marketing, and or sale of bridal clothing, bridal accessories, and related bridal or wedding items, provided employee has substantially participated in the design or creation of such clothing and related items. Yeah, well, you could have just given us the whole language instead of paraphrasing it. But okay, you're kind of where I was last document, where JLM is asking for too much. Unfortunately, it doesn't get you where you want to be. Because by your own admission, you use the pages for bridal design stuff. And that means, you mix business with pleasure, right? It's your name or derivative thereof. I think we can concede to that much. I think every single page that she mentioned is her name or derivative thereof. I think we got that much. And now we have to say, okay, it only extends insofar as it relates to bridal, wedding design, blah, blah, blah. And it appears, from Ms. Gutman's own admission, that every single one of these accounts, to some degree, includes those things. So that's a problem. Hayley, here's another thing too, that you also have to analyze this for, right? So it only extends insofar as you include those things, but you voluntarily, by your own admission again, because you yourself say you didn't have an obligation. Remember, you said it like 3 pages ago. Remember that part where you said you didn't have an obligation to post to the social media accounts? That was part of your argument, right? So you didn't have an obligation to do it. But you also posted some personal stuff to this account, which contains assets which seem to fall within the scope of the contract. This might be the rough equivalent of paying more than you were obligated to under the contract, or delivering more than was required. You're not entitled to compensation. You did more than you were required to. Well, good for you. You met your obligation. You did more than you were required to. Can I say, oh, I did more than I'm obligated to, so I deserve more money? No. Thanks for working harder than you had to and all, but, you met your obligations. I paid you. The fact that you did more than that was on you. That was your decision. I'll say nice things about you, and on Yelp if it makes you feel better. Not that I have to, but, Therefore, the provision covers only Hayley's name and the use of the name on bridal apparel designed by Hayley. Courts should undertake a literal reading of the plain language of the contract. That's a good idea. The plain language of the contract says they have a right to her name in connection with design, manufacture, marketing, and sale of bridal clothing, bridal accessory, and related bridal or wedding items to the extent that she has participated in the design or creation of them. Also, I'd like to take note that the word only is, once again, not in quote marks. Not in the contract language. If it's literally said only in the contract language, that'd be one thing. But it doesn't literally say only now, does it? Because that's not in the quote marks. That's language you added. JLM's attempt to contort this provision to apply to Hayley's accounts, which are not bridal apparel. Yes, they are. Is precluded by the literal plain language of the agreement. Indeed, JLM CEO has already conceded the limitations of the account to the name of persona. I do not claim to access your persona beyond the wedding gowns and related categories. That's good because that's not what the language says. Finally, even if Hayley were in breach of this provision, which she's not, JLM's willing acquiescence. Oh, okay, we're going to argue waiver. This will be good. This will be real good. Finally, even if Hayley were in breach, which she is not, JLM's willing acquiescence over 8 years, while Hayley built these valuable assets in the community, precludes any remedy. So we're arguing waiver in literally one sentence. That's basically what that's arguing, by the way. That's arguing waiver or course of conduct. Take your pick. Waiver is, I had a condition, but you waived it, so it no longer exists. And course of conduct is, this is our operation. So we're going to start and end the entire course of conduct waiver argument inside one sentence. Suggest maybe, not the most persuasive argument of all time. Maybe not that. Maybe not waiver of course of conduct because we only have one sentence on it. JLM's claims for trademark infringement necessarily concedes that Hayley owns Hayley's accounts, because it's nonsensical for a party to bring an infringement claim against itself. What? JLM's claim for trademark infringement necessarily concedes that Hayley owns Hayley's accounts, because it's nonsensical for a party to bring an infringement claim against itself. Well, your argument is you own them. So they're arguing in the alternative, right? In the alternative, or in a different connection, we have a trademark right, which you're currently infringing on, not for least of reasons that you won't give us the assets that we rightfully own. So you're infringing on our trademark, which is your name, because you gave it to us, remember? So I don't think that's nonsensical. No. JLM really contends that Hayley's infringing the marks by using Miss Hayley Page, right? Because that would be your name or a derivative thereof. And Miss Hayley Page as her handles on social media accounts that she owns. Yet JLM acquiesced to the use of these handles for over 8 years. No. She's essentially trying to argue some sort of adverse possession thing or something. She's trying to argue some version of, I was using it in a way that was inconsistent with your business interests for 8 years. And so that means that you recognized I didn't own it. JLM's counter is, we're not required to care. It's our asset. We cannot care for 8 years. It doesn't make it your asset. Also, I'd like to point out that adverse possession really doesn't work in a personal property case. Also, it's not waiver, because they never said explicitly to you, oh, we're not holding you to that condition. They didn't even say it orally, for that matter. They never at any point, even according to you, said at any point, oh, we're totally cool with this. It's your, the statements you made are nowhere near enough for a waiver. You got illusions and wishes, and you're pulling at the edges, even in the ones you got, which means that you have nothing better, which means you have nothing at all. JLM now seeks to preliminary injunctive relief is foreclosed by 8 years of acquiescence. No, because the conflict only exists now. We were happy or didn't care up until this moment. Now we care. They want to go with latches. 10-week delay precludes preliminary injunction. 12-week delay precludes preliminary injunction. Well, at least we do have one case that's citing the Second Circuit. So we got one authoritative case, and I'm going to guess the facts really don't read on this case because we're not mentioning them in any detail. Beyond that, JLM fails to establish a likelihood of success on the merits of its trademark infringement claim. Really? First, Hayley's prior use extinguishes JLM's claim. No, it doesn't. All right, let me explain this to you very carefully and very slowly using small, easy to understand words. Let's take it as a given, for the sake of argument. Let's take it as given that these were created as purely personal accounts, which seems to be at least partially true because she didn't start working for the company until 2011, if memory serves correctly from reading this. And one of the accounts at least was created in 2004, which long precedes the company or their involvement therein. So let's take it as a given that she was using her name on social media in a purely personal capacity prior to all this, which seems plausible. Does her prior use extinguish JLM's rights? Why would it? If JLM acquired them, why is her prior use personally hostile to their ownership now? I don't know. Consumers fully recognize that until last month, Hayley and not JLM was the source of these accounts. Consumers' perception, the absence of any evidence of confusion over 8 years of coexistence compels rejection of infringement, especially the claim for preliminary injunctive relief. Well, for the past 8 years, you guys had a good relationship, remember? Remember how I told you don't need contracts when everything is going great? So for 8 years, they didn't care and you didn't care. Everyone was happy. And now people are unhappy. So now we have to go back to the contract language. And what does it teach us? So for 8 years, she was using it in a way that to the public showed that it was her account. And JLM apparently was perfectly happy with that perception. Okay. Now they're not happy with that perception. All right. Okay. While these defects are dispositive, no, JLM fares no better on the other elements of infringement. Hayley's accounts are not commercial accounts for the sale of bridal garments. For the sale of them? Sure. They focus on Hayley's personal life and her personal connection. Confusion is unlikely with dissimilar uses. Hayley's use of the personal pronoun Miss in her handle for her accounts, as designated and even verified on Instagram, because once again, for some reason that baffles my mind, we're treating Instagram's determinations as somehow legally operative in this context. Let's not make Instagram a court. Let's not, they might have authority over themselves, but let's not give them authority outside of their own domain. I don't think we want to go to Instagram's giving them a check mark as somehow legally controlling in some way. Don't think Instagram's vetting process, as thorough as it might be, has a lot to do with the legal determination. Not seeing it. Hayley's followers fully appreciate that Hayley's accounts are Hayley's personal accounts and not JLM's. And the buyers of JLM luxury goods are likely to exhibit a high level of care when purchasing and are unlikely to be confused. What? Finally, the remedy sought by JLM is not one available to a trademark holder. The Lanham Act makes plain an injunction may only issue to the extent necessary to prevent the violation of any right of the registrant, which in this case is a right to her name. They have a trademark in it. To her. Apologize, to them. They have a trademark in it. They got the trademark. It's theirs. And they're like, that's my trademark. You can't use my trademark anymore. You are now in violation of my rights. I didn't care up until this moment. Now I care. You know, this is a contractual relationship. This is important in this aspect, that it's contractual, right? It's important in this aspect. It's contractual. You know, she might have an argument if there was no contractual argument at all, right? She could argue waiver or latches or something like that if there were no relationship between the parties, right? If she was just a random party and they somehow got the trademark and they're arguing, you know, something like that, she might have some sort of latches argument or waiver argument or something like that. You know, I was using your mark for so long in a hostile way to you. You knew about that. So if this were like completely disconnected parties, she might have a better argument. But they're not. They have a contractual relationship. So what governs is the contractual relationship. What did you agree to, right? If you never agreed to anything, then that's a completely different analysis. Once you have an agreement, what does the agreement teach us? You were happy with your course of conduct and now you're not happy. Okay, let's go back to the contract. What does the contract say? If Hayley is ultimately determined to be violating JLM's rights and equitable relief is available, such relief might include an order not to use the marks. However, assignment of a specific property, such as social media account, is not a remedy available in a trademark dispute. Okay, well, fair. In the trademark dispute, sure. But then again, they not only have trademark rights, where they might be able to force you to change your name, right? Not get control of the accounts, but force you to change your name. Sure. But that's not the only thing they have. They not only have trademark rights, they have contract rights. Dilution. Even if JLM has demonstrate rights to a famous mark, well, this is one I'll give Hayley Page, because JLM does not have a famous mark. The term famous has a particular meaning in trademark law. And it means companies that are so ubiquitous, cross-industry, cross-domains, that they have registration everywhere. So they're known beyond the structures of their scope. And your classic go-to examples here are McDonald's, Coca-Cola. Those are your classic go-to examples, right? You don't need to be in the industry or even in industry adjacent to have heard of McDonald's or Coca-Cola. They are ubiquitously famous across all domains, for better or worse. That's a famous mark. Is JLM a famous mark? No. They might be super duper famous in their industry, but to the best of my knowledge, they have no cross-industry appeal. I don't know about them. And, that's suggestive. They're not Nike. They're not someone who asks a person on the street, what's a JLM? A wedding dress person might know about it, but that's not famous. Famous, you need more than that. JLM is not famous within the legal meaning. I'm there. Yeah, and then they say dilution causes of action are restricted to few truly famous marks, citing again a Southern District of New York case. Budweiser, Camel cigarettes, Barbie dolls. Yeah. Hayley coined and began using Miss Hayley Page in 2004. JLM cannot meet the essential element of defendant's use of the mark became famous. Dilution causes of actions are restricted to those few famous marks. That doesn't sound right. That doesn't sound right. That dilution is restricted to famous marks? That doesn't sound right at all. I'd have to go read that case and see if it actually says what it's purporting to say, because that doesn't sound right. JLM state law dilution tarnishment claim fails for the additional reason JLM has not shown Hayley used a registered mark. Yes, they did. And such use of the mark with obscenity, sexual activity, or illegal activity are products of inferior quality. Yeah, I'm not going to get into the state law trademark claims. I don't care that much. JLM's common law torts claims are without merit. JLM also fails to establish likelihood of success on conversion and trespass to chattel. Trespass to chattel, they have better. Conversion's harder because it's their asset, and now they're trespassing, right? So trespass just means you go beyond the boundaries, same as trespass to property, right? Same idea. Trespass is you go beyond the boundaries of the property. Same idea for chattel. Chattel just means personal property as opposed to real property. It's not trespass if you have permission, right? If someone doesn't care about you coming onto their land, it's not trespass. If someone doesn't care about you messing with their stuff, it's not trespass. If they start caring and say, hey, I care about my borders now, that's trespass. JLM's breach of fiduciary claims fail for several reasons. Yeah, I don't think the fiduciary thing works. It didn't do anything for me. I said that in the original thing. JLM's claims of irreparable harm rely entirely on disproven associations that owns the accounts, which we're still not going to cite the full language of the contract. Hayley's Instagram has never been JLM's main IG account. Okay. As JLM disindolently told the court, I don't think that's what they said. I don't think they said it's their main IG account. I'm sure they said something with a little bit more nuance than that. Moreover, JLM's 8 years of acquiescence to ownership and control precludes JLM's claim of irreparable harm. But even if JLM had brought a legitimate claim and been entitled to equitable relief, it only speculates about what might happen in the future, not specific evidence of irreparable harm. Hayley is the one suffering irreparable harm. Prior to JLM taking control, Hayley's accounts were flourishing assets. Owned by who? With a growing following and high engagement, driven by Hayley's personality and connection. In just a few weeks under JLM's control, Hayley's accounts are losing value and followers. Hayley's Instagram followers have revolted, and the hashtag Give Hayley Page Her Name Back began to trend. The public is displeased. The public has a right to be displeased. Maybe JLM made a bad decision. Maybe JLM has made a bad decision. People have the right to not be happy about what corporations do, notwithstanding whether it's in their legal rights or not. I mean, companies have all kinds of legal rights. Doesn't mean that people have to be happy about it. Maybe JLM made a mistake. If it's theirs to make, though, I don't know what you want from me as the court here. I don't know what you want from me. Maybe they made a mistake. Maybe they made a bad business decision. What do you want from me? You know? The backlash was so swift that JLM has taken the unprecedented step of shutting down the comments feature on Hayley's Instagram account. I like how that's phrased. It's phrased very carefully. The unprecedented step of shutting down comments on Hayley's Instagram account. Well, I'm sure that specific thing is unprecedented, but you know. The action destroys engagement and thus the value of the account and threatens to put the account into a digital death spiral. Okay. And therefore, a social media account is only as valuable as its connections with the followers. Depends how you're measuring value, I guess. The reaction to JLM taking control of the account has been swift and universally decried, as shown in the samples. JLM is not even posted on the TikTok and Pinterest accounts, thus driving down engagement value on these accounts. Yeah. To establish the balance of hardships tips in their favor, the plaintiff must demonstrate the harm they would suffer is substantially greater than the harm the defendants would suffer. JLM's interests are met through numerous social media accounts. You know, not if they have an account that is supposed to be theirs and not under their control, from which, if this truly was a personal account, for example, Hayley Page would be free to, for example, decry JLM. Right? If it were a personal account, then, you know, JLM's ability to respond on their own accounts is interesting, but, you know, suddenly there's an account out there with 1 million followers that'd be saying very mean things about JLM. That causes some harm to JLM. Now, if it's her account, she can do whatever the hell she wants because she's free. Because of course she is. You can say mean things about companies. You know, absent some agreement to the contrary, absent defamation, but you can say, like, I don't like you, right? But if it's their account, her posting on their account, decrying them, kind of a problem, no matter how many other accounts they control. It's one of their own assets being used against them. These accounts, many of which are dedicated brands previously designed by Hayley, have significant follower accounts and have already been established as primary vehicles for commercialization of the products. Hayley, on the other hand, has been deprived of a primary forum she created and built, and is used to communicate with her followers for many years. Further, as discussed above, the value of the accounts is declining every day JLM controls them. The relief that JLM seeks to violate also violates the Stored Communications Act. Oof. The Secured Communications Act makes it a criminal offense with a civil right of action for an employer to access its employees in electronically stored communications. In particular, the direct messages on Hayley's accounts are accessible to JLM. If they're DMs to an account owned by them, they're not the employees. Now, are they? The preliminary injunction request would permit JLM to continue to read these private conversations in violation of the Secured Communications Act. No. The balance of hardship should also consider the parties' respective resources. Really? Citing a district court, citing Southern District of New York, plaintiffs' financial resources were greatly exceeded by those of corporate defendants, such the balance of hardships tipped decidedly in their favor. Well, that quote, completely lifted from a case with no context whatsoever, surely must read on this present situation. Hayley is an individual, while JM is a big baddie with lots of money, and so they're mean. You know, I haven't read that case they cited, but I'm going to guess that that quote is taken a little bit out of context. There probably is a situation when financial resources are a relevant consideration to some issue. Are they relevant to every consideration? Not necessarily, right? At least the idea in law, although this idea gets modified endlessly because of 3 bajillion carve-outs and you know, because everything is complicated, because life is complicated. But the idea, at least, is equal justice under law. And, you know, what that means exactly, there you could have endless discussions about. But, you know, the idea, at least, is rich or poor, big or small, David or Goliath, everyone is treated equally before the law, insofar as they are equal in the relevant domain, and then, you know, we go into long discussions beyond that. But we should not at least in the initial inspection, at least until law tells us otherwise. Sometimes the law does because of lots of reasons. But should we rule against JLM because they're a big corporate baddie and she's a small, innocent individual? I'm not sure how that would necessarily be equal justice. There's a contract. Let's, apply that, which, okay. A preliminary injunction is not in the public interest. The relief sought by JLM is not in the public interest. First, it's inconsistent with public belief. Over 1 million members of the public have cultivated and continued a personal relationship. Really? 1 million people have a personal relationship with you? I'm not so sure about that. Through her Instagram account below. Eliminating the method and form for Hayley's communications with her follower is deeply inconsistent with the public interest. Court must weigh the potential audience for express speech. Citing, again, a district court, citing it out of context. Second, it's critical the court consider the public's speech rights and not just the right of the parties. The public's interest in free expression, however, is significant and distinct from the party speech interest. Okay, here because we shut down the comments. Is that what we're going to go with? Because we shut down the comments on our Instagram, the public has been deprived of their ability to speak. While Hayley has always allowed free and open public comment on Instagram, within days, JLM removed all public comments and disabled commenting. JLM is eliminating a developed arena of free speech and also eliminating prior speech from the public sphere. The public interest in protecting those who wish to enter the marketplace of ideas from government attack, not eliminating the free flow of speech. The First Amendment protects the public interest in receiving information. So therefore, the public has an interest in the comment section of the Miss Hayley Page Instagram account. JLM seeks improper injunctive relief. While JLM's briefing is devoted nearly entirely to the issue of control over the account, because, that's kind of the most operative thing, JLM's preliminary injunction receives several categories of relief completely unrelated to the accounts and underlying claims. I don't remember reading it that way, but okay. The sections of the JLM's requests broadly and vaguely seek to prohibit Hayley from taking any action that breaches the employment agreement. There's a contractual relationship. Stop breaching the contract. Seems like, okay. Including but not limited to whatever without express permission of the chief executive officer. Yeah, stop breaching the agreement unless the CEO of the company tells you it's okay. That would be what waiver looks like, incidentally. So, yeah, please stop breaching the agreement unless you get permission from the CEO of the company who would have permission to tell you to breach the agreement, because it's their agreement. It's their rights, remember? JLM can enforce its rights or not. So if JLM's CEO directly or presumably, again, through an authorized channel, so not rando employee, but rando employee who's actually authorized to communicate to you on this domain. So from the CEO, if the CEO tells you, we're totally cool with you doing this, then there's no breach of contract now, is there? Because they say we're cool with it. So stop breaching the agreement unless they tell you they're cool with it, in which case there's not a breach because they're cool with it. Remember, we only need contracts when both parties are not happy. If both parties are happy, we don't really need contracts. So if JLM CEO tells you to go nuts, why would the court intervene? We don't care. We don't need contracts if everyone's happy. Subsection V is so broad as to simply swallow subsection 4 and seeks to prohibit Hayley from using or authorizing third parties from using designer, trademarks, or any confusingly similar terms without written permission. Okay, that's just dumb. That's just dumb. All right. So here's what the court did, or here's what their request did, and then the court granted. All right. So the JLM said, we want a temporary restraining order. And we want you to stop them and make them do these specific things, which we're going to specifically enumerate, right? We want you to, for example, give us the passwords to the account. We want you, for example, to not disparage us. We want you, for example, to, so they list these specific things, right? And then in subsection 5, they say, and also, we want you to not breach the agreement into any other aspect. Now, this is very, very good legal drafting from JLM because JLM knows what they're doing, right? Because we need to, in an injunction, we need to make clear what we're enjoining you to do. So simply, don't breach the contract is not sufficiently clear. It's not sufficiently clear to put you on notice. So JLM being their attorneys being smart, say, okay, we're not going to just simply say stop breaching the contract because that would be dumb. Instead, we're going to list off a whole bunch of very specific things we want. Transfer the accounts, give us the passwords. So for, do this. And also, by the way, anything else that we didn't think of, we'll put as a side. Not that that's probably legally sufficient, although it is, because we told you the specific things, but also as a catch-all. It's always nice to have a catch-all. You don't want it to be your only thing, but yeah, it's subsection 5 is so broad as to sweep in 4. Yeah, it's so broad as to sweep in sections 1 through 4 too. What's your point? This is the and other stuff provision that we see so many times in law. And other stuff. We see it all the time in legal drafting. We see it all the time in statutes. We see it all the time. You are forbidden from doing bump, and other stuff. This is the and other stuff provision. It's good legal drafting. It swallows every specific example. Of course it does. The specific examples inform the what and other stuff means. And other stuff like the ones that we mentioned. It swallows section 4. What are you talking about? Each of these requests is patently improper. They have no basis in any legal claim brought by JLM and seek absurd relief. You keep saying that. I'm not sure it means what you think it means. Hayley would have to seek written permission from Mr. Murphy to use her own name. Okay? No. Stop saying that. Stop saying that. You know that's not true. You know that's not true. And you keep saying it, and you've made Instagram videos about it and YouTube videos. I've seen them. You keep saying it. It's not true. I know you know it's not true. So please stop making this up, okay? Let's be very, very clear about what you can and cannot do. I will explain it to Hayley, even though she already knows this, because of course she does. Okay? Hayley Page, of course, can continue to use her name. Any argument to the contrary is dumb. She can't use her name in trade related to bridal design and wedding design. She can use her name in literally any other context she wants. She can keep calling herself Hayley Page. That's her name. She could even start a new account. She could start a new Instagram account. She could be Miss Hayley Page Personal or Miss Hayley Page Suck It JLM or whatever. She can use her name. She simply can't use her name as a trade name. She can't create an Instagram account called Miss Hayley Page if the account is related to wedding design and bridal design. Now, I know that's your industry and all, but that's kind of the point of what you sold. You have the right to use your own name. What are you talking about? Of course you do. You can call yourself Hayley Page. Your name is Hayley Page. Go nuts. Just don't use it specifically in trade, specifically in the wedding design, bridal related industry. What are you talking about? You know better than this. The requests are not seeking to prevent any imminent or definable harm. They're purely punitive. No. These requests also fail procedurally. Rule 65D requires every order granting injunction be specific in its terms. Wow. And describe in reasonable detail the acts or acts sought to be restrained. A broad prohibition against breaching an agreement is improper. An injunction must be more specific than a simple command to the defendant obey the law. Well, no shit, Sherlock. I told you that. I told you that like a page ago. Yeah, you can't just say, stop breaking the contract. That's not specific enough. I told you this. You have to be more specific. You have to be clear what you're preventing them from doing. That would be sections 1 through 4. And also, by the way, and other stuff, which is fine as a catch-all because it's informed and understood and interpreted in the context of 1 through 4, because of course it is. It's fine. That's why they drafted it that way, because they're not dumb. The request also violates Rule 65 D1C, which specifically sets forth injunction cannot refer to the complaint or other document by incorporating its terms and concepts. Based on the foregoing, JLM cannot establish a likelihood of success. Well, they can because they got the injunction. You know, they totally can because they totally got the injunction. So that's all just kinds of dumb. That's all dumb. It's all dumb. Now, let me see if I can find a copy of the language of the contract, because Hayley Page didn't want to actually give it to us, and JLM did. Or at least they gave us a lot of it. They didn't give us all of it because the actual contract is under seal, but they still quoted a bunch of it. They quoted the provisions that were necessary. So let me see if I can find somewhere in here a copy of whatever it is that I need. So give me 1 second. I know it's in here somewhere. Let's see. It's probably in the original complaint. So let me just pull that up. All right. Okay. Well, it's more than Hayley Page gave us. So we got that for sure. So let me just save this real quick and I'll open it up in my browser and we can all share together and figure out what the heck is going on here. Hold on. What did I do? All right, let's see if this works properly. No, yay. Okay, great. All right, so we got more than language than we started with from JLM. This is their complaint, which we covered before, but we might as well cover it again because, you know, we didn't have the courtesy of them giving us the language in their response because, you know, it's not super helpful. So we'll just skip ahead. All right, so we have specific language, which is not necessarily all the language, but it's more than we got before, okay? So we have these two provisions of the contract. Pursuant to 10A, Gutman grants JLM the exclusive worldwide right and license to her name, Hayley Page, Hayley Page Gutman, Hayley Gutman, Hayley Page, or a derivative thereof, in connection with design, manufacture, marketing, and or sale of bridal clothing, bridal accessories, and related bridal and wedding items, including all goodwill associated therewith. All goodwill associated therewith. Section 2B. Gutman irrevocably sold, assigned, and transfers all right, title, and interest to JLM that now exists or may exist during the term, and for a period of 2 years thereafter, to register the designer names or derivatives thereof as trademarks or service marks with the USPTO. The trademarks shall in perpetuity be the exclusive property of JLM, and Gutman shall have no right to use the trademarks, or a confusingly similar term, during the term of the employment agreement or any time thereafter with respect to the consent of JLM. So they have the trademark rights, right? and they have the right to use her name in connection for the contract term in 2 years in association with this stuff. In response for good and sufficient consideration, which we definitely have that without breaking a sweat. Is there any other language here from the contract? No, that's all the language we have from the contract, which is still more than Hayley gave us. But the language from the contract that they gave us seems pretty expansive, right? Right to use the name in connection with design, manufacture, marketing, and or sale of bridal clothing. I'd also like to point out here that I think Hayley Page misled us, because let me go back to the language that she wrote, because she misled us at some point. Let me see if I can find the exact language where she created a mistake, or because she said something like they can only use it with respect to, okay, because there's this language here, 10A states, and there's this language here, provide employees substantially participate in design or creation of such clothing or related item. Oh, no. And then, yeah, so see, there's something that HLM or JLM, apologize, did not quote to us. So Hayley Page gives us a little bit more, apparently from the contract language, because this is 10A, right? So this is the same provision that we're reading. And then apparently there's this additional sentence, provide employees substantially participate in the design or creation of such clothing or related item. Now, what I don't know, because again, Hayley has not given us the entire clause. So what exactly is this provided relating to? We don't know, right? It might be relating to the whole thing, or it might be more narrow than that. We don't know because we don't have the exact language. So something in this is limited to the employee's substantial participation in design or creation. It might be the whole thing, or it might not. And JLM didn't do any better, because JLM also left out the language completely, so we can't analyze it there either. Because JLM's quotation of the language would be in connection with any manufacturer, marketing, or bridal clothing. And apparently, Paige argues it has to be even more specific than that she substantially participated in design or creation. I'm not sure I necessarily believe her. The reason I don't believe her, or I don't believe the way this is quoted, is because she's being so evasive. And she's being so, JLM provided us more. They weren't this evasive. And they actually discussed the law, even if they were only providing us parts. And the court, which has the whole thing, granted the TRO, even though we don't have it because it's technically sealed or something. Oh, isn't there a copy that's like mostly unredacted? Hold on. I think there's a copy that actually is mostly unredacted. Hold on. Let me see if I can find, because I think there was a copy that just had redacted the monetary amounts or something. I need more language. I need more language so I can do a better legal analysis. I'm being deprived. Declaration, maybe? Attachment 13? Ah. Yes. I think this is what I need. Yes. Excellent. I have what I need. Ha ha ha. I will not be defeated. I will not go quietly into that night. We will not vanish without a fight. Great. All right. So this is the agreement. Yes, 2011 agreement. Fantastic. So I have most of it, except for monetary amounts, which are redacted, but that's fine. So let's go to 10A and read it in its further form so that we can analyze what the heck we're talking about. 10A, fantastic. The employee hereby grants the company the exclusive worldwide right and license to use her name, Hayley Page, Hayley Page Gutman, Hayley Page, or any derivative thereof, collectively the designer name, in connection with the design, manufacture, marketing, and or sale of bridal clothing, bridal accessories, and related bridal and wedding items, including any and all goodwill associated therewith throughout the term, including extension of the term, plus a 2-year period following the term or any extension thereof, provided the employee substantially participate in the design or creation of such clothing or related items during her employment by the company. Okay, so Hayley Page actually was closer to quoting this accurately than JLM is. But that's nice because we have the whole thing. So I think she's right. It doesn't extend to all bridal clothing. It just has to be the ones that were created by her. So the way this reads, they don't have exclusive rights to any work that she now creates. So the way this reads, right, now, not speaking about the trademark rights, but her name and license, right? So she has the right that there for, to do that. And then it says, in the event the company is not sought to register the designer's name as a trademark or other authorities in the United States or abroad prior to and including the last day of the 2-year period following employment for whatever reason, such exclusive right and license by the company shall terminate. Okay, so they have a right, they have the right to her name plus 2 years. And then there's a proviso that goes on, right? The company hereby the employee hereby irrevocably sells, assigns, and transfers all right, title, and interest of the company that may now exist or may exist through the term and any extensions thereof, and for a period of 2 years thereafter, to register the design's name or any derivatives thereof as trademarks or service marks with the USPTO or other authorities in the U.S., except as otherwise provided. The permission of the employee to the company to so register the trademarks shall be exclusive and perpetual and is granted in exchange for good and value consideration. Employee agrees and shall cooperate with company to execute any and all documents and perform any other actions as may be reasonably necessary to effectuate the intent to secure the company complete ownership of the trademarks. The trademark shall in perpetuity be the exclusive property of the company. The employee having consent to file by the company, employee thereof shall have no right to use the trademarks, designer names, or any confusingly similar names or names in trade or commerce during the term or any time thereafter without written consent. The company shall have sole permission to license the trademark to a third party. So the reason I'm having a slight hiccup on the language is I'm trying to interpret the 2 years thereafter and also the perpetual at the same time. So they have the right to, the employee sells all rights that may exist and for a period of 2 years thereafter to register the names. All right, let me think about that for a second. Irrevocably sells, assigns, and transfers all right, title, and interest that may exist now or in the 2 years thereafter. Okay, so that presumably means they can't register any new names after the 2-year period, I think. If I'm trying to give effect to every term of this contract, because it's a little bit unclear, but that seems to be the most logical reading. So they only can register names for the term of the contract, and 2 years thereafter seems the most logical reading of that. And then except otherwise herein the permission of the employee to register the marks shall be exclusive and perpetual. You know what I don't like here is that it doesn't say renew. I don't like that for JLM. That's a miss. So they have the right to register the marks perpetually, but not necessarily renew, and that's not necessarily the same thing. So that's a potential legal fail on this language if we ever get that far. But there is a potential weakness here, depending on how this language is interpreted by the court, which is, of course, a matter of law. But they have the right to register the marks perpetually. But does that necessarily imply the right to renew the marks once they come up? Because trademarks expire every 10 years. They can be renewed indefinitely, but they expire every 10 years. So does the right to register the marks indefinitely include the right to renew them indefinitely? It's not clear on its terms. So I have to get really deep into trademark law, which I'm not going to do right now, to figure out whether or not this language allows them to renew the mark or not. So I'm not going to figure that out right now. But they definitely have the right to register the names and hold them for at least. They have the right to register any names within the employment term and any 2 years thereafter, and to the extent and for whatever period the trademark would run, which is 10 years. And then after that, maybe, depending on how this language is to be interpreted. Probably the best reading, and this is more an issue of trademark law than an issue of contracts. So probably the best reading, and you'd have to get deep into the trademark law, but probably the best reading, absent that, is they have the right to renew. So they have a right to her name indefinitely in trade. And she can't use any confusingly similar name in trade. Which, okay. But she can use different names. For example, JLM is the initials of the company, or the company founder, or the company CEO, or company something. JLM is, hold on, it's a guy's name. It is, who is JLM? There's a declaration from them in here somewhere. I saw it. Oh, Joseph L. Murphy. Joseph L. Murphy is who that is. And that is the president and chief executive officer of JLM. They named the company after themselves using their initials. So I would imagine that HPG, Hayley Page Gutman, is not confusingly similar, or maybe it's derivative, I don't know. But maybe HPG. She could call herself HPG maybe, or something. Or HG or something. She there's something there. But yeah, she just can't use it in trade. So it's not the end of the world, even though she's saying that on her various social medias. So even if she loses, she just has to use a different name in trade. She can still call herself Hayley Page. It's fine. She doesn't lose the rest of her name. It's more limited than that. But yeah, that's why this language is much, except for this small minutia issue with renewal, which is not immediately a legal issue, right? Because that's not an immediate problem. So except for that, the language seems pretty clear on its face. It's fairly clearly drafted. So that would be why the court did not granted the TRO and granted the preliminary injunction. The language is pretty clear, because one of the factors, right, again, is like the likelihood of success. And what likelihood of success do you need? 30%, maybe, something quasi around that number. Do they have a 30% success on this language? Yeah. I mean, yeah. Language seems pretty legally clear. The facts seem clear enough. There's no fact in dispute that seems to turn the legal analysis here. Like, because all the facts that would be relevant would be the facts that would exist in 2011, not the facts that exist now, because we're trying to interpret the contract, right? So when we're trying to interpret the contract, the facts that are relevant are the facts at the time of the signing. So the facts that are relevant are the facts in 2011, not the facts in 2021. So there doesn't appear to be any facts in dispute that I can see that would turn the legal analysis. So the facts seem clear. The legal analysis, except for this one minor issue, which probably goes in JLM's favor, seems clear. So all I have to say is Hayley Page doesn't have a lot of people to blame except herself. The language seems pretty clear on its own terms. So, I don't know what to tell her. It seems sufficiently clear from me. So, yeah, that would be why the court granted the TRO. That would be why the court granted the preliminary injunction, because it goes to intellectual property rights, which are not necessarily remediable by law. So this is merely a breach of contract, and even if it was, it wouldn't necessarily apply money. It's also an intellectual property thing. It's the right to one's name, and it's JLM's name, so there's an irremediable right there. It's irremediable enough. There's a likelihood of success on the merits. There's no strong public interest factor one way or another. I don't really see a strong public interest factor one way or another. It's kind of an irrelevant consideration to my mind in the analysis. And the harm to Hayley Page, they put up a bond. They were required to put up a bond. I forget how much it was. It was a fairly substantial amount, though. But JLM was required to put up a bond in case they lost to compensate her. And, it seems right to me on legal merits, as far as I can tell. A. Hedinger says, does owning the trademarks mean ownership of the counts? That's a good question, A. Hedinger. And that we'll have to get into it. So, no, not necessarily. That's a very, very fair issue. So, because we're only on a preliminary injunction standard, right? So, freezing everything in place, right? Freezing everything in place makes sense. Now, I could see the court going the other way too, but they do have some likelihood of success. And the damages that are being done. So maybe the better idea for the court would have been to say that the account can't be touched by anybody, so no one has rights to it in the interim. Might have been a better remedy, but I don't see it. Even though it's legally an extraordinary remedy, it seems okay, and there's a bond at the end to compensate her. At least that's part of the idea. So if JLM wins this in the end, does it mean the access to the accounts? No, not under trademark law. We saw that, right? The trademark law would just compel her to change the name to something that would not be sufficiently derivative. So yeah, so the trademark would not give it to her. The license to use her name wouldn't give it to her. So the most logical, it depends how the court wants to deal with this. And this is one of the problems when you mix business and personal assets, because how the court deals with that, you don't know. It depends a lot on the judge, right? The judge could say, well, this is really a business asset, and the fact that you put a whole bunch of personal stuff on it is your problem. You gave more than you were supposed to. Or they could say, based on the course of conduct, that, it was treated mostly as a personal account, so just remove the stuff that is JLM's from the account, remove those posts, give her back the account, make her change the name, right? So how you deal with the remedies, like there's an entire semester in law school dealing with remedies. And so how they will deal with it in the end, I don't know. But if I were a betting man, it seems unlikely in the long term that they will be able to, that they'll be able to keep these accounts. They get the names, but the problem is also they get any goodwill, but they only got good. See, the contract language is problematic. They get the exclusive right to her name and all the goodwill associated therewith, but only to the extent that it relates to bridal designs that she distressed. So how do you splice that, right? So JLM has all the rights to the goodwill associated with the account to the extent that it covers the bridal dresses that she designed, which is at least some of the content. So how do you slice that baby, in Solomon style? How do you determine what goodwill is associated with it, and how do you compensate for that? Is it a monetary thing? Does she have to pay? Does someone have to pay someone for the monetary because it's a goodwill? I mean, it can get messy trying to untangle all this, and that's why you don't want to have this problem. So they have the right to the goodwill associated with the names to the extent that it's related to bridal design that she created, and trying to untangle all that, right? Provided employee has substantially participated in the design or creation of such clothing or related item. How do you untangle all that? That's a mess. And you don't necessarily know what's going to happen in the end. If I were a betting man right now, though, I think the most likely thing, because again, this is contracts, so we're trying to look for what's legally required, and they would have a period of their own. So I think the most likely thing is she gets the accounts back, but I wouldn't bank on it. I wouldn't bank on it right now. Because the language it's messy, and trying to untangle all that and trying to untangle what goodwill belongs to who and whose goodwill it is and so forth and so on. And she created most of the goodwill, it seems, for personal reasons, not corporate reasons. So they're only entitled to some of the goodwill. Can we value that? Does she have to write them a check? I don't know. And trying to figure all that out, it's a mess, man. That's where I go break out the Remedies book and begin to have nightmares trying to untangle all that. Do they automatically forfeit the bond to Hayley if she wins? Not automatically. The court would still have to order it. It's just being set aside for that purpose, but no, not automatically. The bond has been paid to the court. It's now in the court's checking account. So not automatically, the court would have to order it, but it's available. Yeah. They lose but get an injunction for a period from posting from bridal. Yeah, there's a lot of potential remedies here. Trying to untangle this is going to be a mess. This is what happens when you mix corporate and personal assets, though. It's why it's a bad idea in business. It's a bad idea in finance. It's a bad idea just kind of across the board. When you mix business and personal assets, it can be really difficult to untangle those. So, yeah. And math says the only way that they can pull is they agree to this by conduct. Good luck, I have to say to that, man. Good luck, because the nature of the relationship, I don't know, man. I don't see that. I don't see a court going that way. I mean, it's possible, Matt, but I don't see that as the most likely outcome. I think the most likely outcome is JLM is going to come on top. To what degree, I don't know, but she's going to be able to say, oh, the acquiesced by course of conduct. I don't know, man. Because there's nothing, the problem with the course of conduct language is usually in course of conduct, you're trying to argue that some provision of the contract that does apply, doesn't apply, or is understood differently, and it's not eminently clear. There's an immediate conflict that would allow for that course of conduct analysis. It's not exactly like she was doing something the contract expressly disallowed, or she was substituting goods. Like the contract calls for supplying aluminum, but she was supplying steel, and the company was okay with that. So, it didn't. There's not a real conflict there that is obvious. So the course of conduct idea is nice, but I'm not seeing the conflict that would really allow for that off the top of my head. So I think that JLM is in the better position. They have the right to her names. They have the right to the trademarks. The counts themselves in the long term, I don't know how that breaks out. And she would have to change the name in any event to something else. Seems like the right remedy given what we're sitting right now. Yeah. Yeah, please stop trying to type VI commands into chat. Yeah, there's I think JLM has the better end because the contract language is clear, except for these, it's clear how to apply it. So it's clear except for the renewal thing. So there's one point of legal non-clarity, right, with the renewal thing. So there's one point of legal non-clarity, but it's not immediately relevant to our immediate problem. And the language dealing with goodwill, it's sufficiently clear. So it's not a problem of the contract language being clear or not. It's actually how to untangle that and apply that. So that becomes more of a factual problem than a legal problem. It's like, how do you actually apply that and make that work? But the understanding of it is sufficiently clear. So I understand the language. I don't have a legal problem with it. I'm just trying to actually apply it and try to undo all this. How do I untangle this knot? It's a bit of a mess, so it's like, how do you deal with all that? I don't know. It's a mess. Did she get another bite at the apple? Yes. First of all, this is a preliminary injunction. It's not permanent, as I mentioned. Preliminary injunctions can be modified at any time. All else being equal, you would expect them to last until the end of the case, but that's not necessarily true. So if you had to take a bet without knowing anything more, you'd expect the preliminary injunction to last throughout the case, but that isn't necessarily the case. Preliminary injunctions can be modified at any time. They're preliminary. They're not a final injunction. So the court issued the TRO. They issued the preliminary injunction. The next thing that we're going to read is her answer to the complaint, right? Because this was all dealing with injunctive relief, which is independent of the merits of the case, if you like. Like the injunctive relief has to calculate the relative probability of someone winning. So like you have to look at it and be like, what's the probability of winning? And it doesn't have to be more likely than not, right? So whatever the number is, whatever the number for clear is, it's not 51%, because that's the ultimate end of the game. If we're 51%, we're done. So whatever clear means, it's not 51%, right? So whatever amount of evidence JLM has to produce to get the injunction, it can't be 51%, because if it were 51%, we're done. So what exact number of likelihood do they need? It's something less than 51. I can tell you that for sure. And so it's something like 35% seems like a reasonable number to reduce it down to, because I'm forced to. So like, so what's the problem? So if a standard injunction is 20%, then this injunction is 30% because it's a mandatory injunction. That's a little bit higher. So something in that ballpark, right? So now we have to determine, where are we in that spread? Are we between, if we're greater than 30%, But less than 50%, then Hayley wins. If we're greater than 50%, then JLM wins. And as the court is looking at more and more evidence, if the probability of JLM winning dips below, right, if their probability of winning shifts as evidence gathers, right, because the court's just making probabilities, which is informed by, the court's experience. So they're not blindly guessing. They have experience. They're guessing. Well, it's informed guessing. It's informed, intelligent guessing, right? So if the probability of them winning drops low enough, then yeah, you could expect revisions or to keep it or whatever. So yeah, revisions are totally possible. That was a long answer to yes, maybe. But the next thing we're going to cover in this series is the answer, which she has already filed, and we're going to cover it, where she says, no, I didn't do it. And here's a whole bunch of things I want to argue that they did and they're bad. So that's the next thing we're going to cover in the series. So yeah. So, and let me take a quick look and see if there's any sort of, because I seem to remember some stuff dealing with, hold on, blah, 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 blah. So the injunction was document 109. There was a motion for reconsideration, which of course is denied. A whole bunch of, someone went to appeal on an interlocutory? Is there an appeal going on right now? Oh, there's an appeal going on because of the TRO. Oh, so they're on appeal. Oh, that's fun. So there's an answer, and there is an appeal currently pending on an interlocutory. So we could discuss those things. It looks like. Yeah, so that seems like that's happening, and it hasn't been returned as denied yet. The appeal was filed April the 5th, and of course there's no return. There hasn't even been an argument yet. There's a whole bunch of memorandums, and so at the moment it's on appeal. So the next document we'll cover is the answer, dealing with I didn't do it and they're very bad, and then we'll cover the appeal, which is also now happening on the interlocutory issue. So this is going to be an abuse of discretion analysis. So what do I think? Given what I know right now, it looks solid enough. It looks solid enough, especially because at least in the document we just read, maybe it gets better in the appellate brief. One could only hope. But in the document we just read, there was one citation to one precedential case, which quoted, I think, 5 words from the case, which says it doesn't really stand for the proposition it does. So maybe there's law that's better, but we'll deal with the appeal and try to analyze that. So if they're going to appeal, then we won't hear anything back for a year. So that's annoying. But we'll deal with the appeal, and then we'll go from there. So fun times. Yeah, abuse of discretion, I'm not seeing it right now. So yeah, the injunction's being appealed. The injunction's appealable, so the injunction's being appealed. I wonder if the case can operate in parallel at the same time in the district court or not. I honestly don't know. I've never thought about it. I'll find out. It looks like nothing's happening, so it may be because it's being appealed that it can't operate in parallel. That would make sense. So we'll deal with that later. But yeah, the next thing we're going to deal with is the answer, and then we'll deal with the appeal, and then we'll see where it goes from there in this mess. Yeah, while the appeal is ongoing, does the rest of the case stop? I think it does. Let's see. Federal rules, appellate procedure. Let's see. Let's see. Stay or injunction pending appeal? No. Appeal from judgment? No. Appeal? No. Review? No. Extraordinary writ of mandamus? No. Appeal from a judgment of an order of a district court. Appeal Remedies law. Find notice appeal. Appeal in a civil case. It's not a criminal case. Appeal by permission. Blah, blah, blah. Appeal by permission. (28 U.C. 1292). Yeah, so interlocutory order of a district court. So it's Court of Appeals shall have jurisdiction for interlocutory order of a district court, granting, continuing, modifying, or refusing or dissolving injunctions. So that would be that. So they have the right to appeal. Does it freeze proceedings in the district court? Okay. So Section 1292B does not provide for an automatic stay of district court proceedings, but instead leaves that to the district court or circuit court. Thus, appellant wanting a stay should request and justify entry of a stay. Was likely the stay will be granted in most cases. The statute requires litigants to affirmatively require them. Okay, so there is no automatic stay under 1292B. You have to request it, and the expectation is it be granted. Okay, so have they requested a stay? And there's a whole bunch of extensions of time. Extension of time, notice of appearance, extension of time, amended complaints. It doesn't look like it, but that might be coming later. Maybe it's in the appellate documents, but they haven't requested a stay yet. So it looks like at the moment, at least, they can proceed, but there hasn't been anything happening yet. So it looks like the answer is no. Yeah. And there's, so, yeah. Stay of proceedings. Yeah. Rule 62, Federal Rules Civil Procedure. Yeah, so it looks like it's not automatic. It has to be asked for, but usually granted. Interesting. Cool. We learned something new. It looks like it's not automatic, but it has to be requested. Interesting. There's no particular reason to stay proceedings while the appeal is pending. There's no particular reason to stay it. We'll waste everyone's time. You could proceed on the merits while you're dealing with the injunction issue. So, I don't know, but we'll see what happens. Looks like no. Can the appellee ask for it? Yeah, either if it's available by motion, sure. Yeah. If it's available by motion, then either side could ask for it. Sure, why not? I can't see any reason why not. Why only the person appealing could ask for it. The appellee could ask for it too. There's no particular reason to have an injunction or have a stay that I can see, because there's nothing obvious that the Court of Appeals would do that would interfere with anything the district court would do. The only reason to stay proceedings would be that the district court would do something that the Court of Appeals is about to undo. But that doesn't seem possible. The only thing the Court of Appeals could do really is to say the injunction's improper and withdraw it. But there's nothing on the merits that would change. So, I mean, I don't know if either side will request it. There's nothing obvious that would seem to counsel it. But, I mean, JLM, on the other hand, has possession of the accounts now, which is in their interest. So JLM may want it for practical reasons. And so if they're typically granted, then maybe they'll get it just as a matter of course, even though there's no particular reason that would interfere with the court proceedings. And the court is as likely as not to want it just for pragmatic reasons themselves, because it's one less thing on their docket they have to deal with, right? So the courts are busy. And so the district court has pragmatic reasons to say yes. It's like, yeah, why not? Because that's one less thing I have to deal with for the next year. So yeah, that looks like, yeah, okay. So good times. Excellent. We all learned something new. Well, next time we'll discuss the answer and counterclaims, and then we'll discuss the appeal documents, and then we'll go from there. If you are enjoying this content, please remember to like the video. I go through these thorough discussions for you. I hope it's of interest to the Hayley Page, JLM, Beauty YouTube community. Hope to get some value out of this extended legal discussion analysis, even though I'm telling them that Hayley Page is on the rocks, because, you know, I'm not necessarily here to make people happy, but tell them what I think the best legal outcome is. And they may not think that that's necessarily good, but, you know, sorry. I'm not here to tell you here to tell you what I think the best legal analysis is. So yeah, it looks like that's all done. So if you like the video, please remember to like it. If you're not already subscribed and you've been watching this long, please subscribe. I mean, come on. You've been following this much content. It's not worth your subscription. And did you know for 99 cents a month, YouTube can become an uncivilian? That's true. You hit the join button or you click the link provided by Streamlabs. Either way, all that good stuff. I'll be on tomorrow to deal with James Charles and his employment lawsuit nightmare. That'll be fun. Until later, my friends, cheers and goodbye.